Well, hello and welcome to our session. We have one more great topic to tackle today for those of you who are attending live. We're going to talk about estate planning basics, a very important topic. For those of you who are watching on the replay, the good news is we're going to leave you with some great information and you'll still be able to use the resources if you have questions about any of the information that you see in this particular session. I'm so pleased to be here. My name is Catherine Chris Martin. I am your guide through this process. I work for EY. I've been with them a little over 10 years. I've been teaching these types of topics for over 20 years, and I really enjoy sharing this information and helping people get a hold of their overall financial wellness. And, um, even if you've done a great job at retirement planning and you're following your budget and you're doing all of these other things, you still aren't finished with your plan until you figure out what happens to all these things when I'm no longer here. So, a part of the process to truly do a good job of the planning process, a part of the process is to do estate planning. If you do have any questions, for those of you who are attending live, you can throw those in the Q&A. I will double check and make sure we don't have any questions. But if you have any questions in the future, you can always call our planner line and they can help you. So we're going to look at what your overall estate is included in your overall estate. We're going to talk about the pros and cons of the probate process. We'll also talk a little bit about trusts and their roles in estate planning. And then I want to leave you with a clear understanding of what documents do you need to prepare. Also understand how your estate might be taxed. For many of us, estate taxes is not the big issue it used to be because they changed a lot of these tax laws over 10 years ago. But it's still important to understand what the cost might be because the probate process can definitely add to what the cost of your estate will be. Before I jump into the topic, though, just a reminder of all of the other resources that you do have. You have a lot of benefits through the Wespath benefits organization. It's wespath.org is where you can find benefits and investment information. There, it includes plan documents as well as details about your investment funds. And then the administrative site is benefitsaccess.org. You do need that password to get into that one. It's password protected. You can access your account information. You can change your investments online. And also you can do estimates of what your various pensions might be, and especially get balances and whatnot for your 403B plan for the UMPIP. So lots of resources are at your fingertips, and you can always call the Benefits and Investments Call Center. You can see their 800 numbers right there. Now, of course, I represent this next slide. These are my people right here. We are the EY resources through our Navigate program. And of course, Wespath is one of our clients and a very important one for me. And we have information which will allow you to access your calculators, planning information, short videos on different topics. That's on our Navigate digital website. It's at wespath.eynavigate.com. You can download an app on either your iOS or your Android device. We do not discriminate. We have it on both platforms. You can call our planner line as often as you want to. And we also have regular monthly webinars. You not only can watch webinars when they're being held, they're about 30 minutes in length, but we have a whole library of ones we've held previously. You can watch those on demand. So there is no good reason to not be educated on your finances. No good reason. We've got a whole bunch of great reasons that you can be very educated. And it's one of those things where I feel like it takes time. I mean, I've been with EY for over 10 years. I did some of this type of planning before I even came to EY. But every year I feel like I get better at it because I learn other information and nuances as I go along. Even though I talk about it a lot, I'm still learning things. And so it takes a little bit of time to get into it, start to understand it. But I think it's a great idea for you to get involved in your financial planning and understand how it works. Even if you're not the lead planner in your household, sometimes one person does the finances and the other one doesn't. That other person who doesn't should still take time to understand what's going on, and to learn how to handle it. Because what if something happened to the person who does take care of it? You want to be able to step in there. You can call our planner line as often as you want to. You and your spouse both can be on the phone. We can deal with your money regardless of where it is. So I just encourage you to use the resources. And most importantly, everything on this slide, all of these resources, they're available to you at no charge, absolutely free. Basically, they're a part of your employment through the Wespath organization. So I just encourage you to continue to use these resources. You even have access to our resources when you're retired, as long as you have a balance of at least $10,000 in your UMPIP. So as long as your balance is high enough, you can still use the EY resources. And again, they're available at no charge. We have the website, we have our planner line, on average about 7 years of experience. You can call and make appointments with the same planners. You have your own personal telephone-based financial planner. And we have an app you can download available on both iOS and Apple iOS devices and on Android devices. And most importantly, as you go through this information, you should be doing what you can to create your own personal action plan throughout any of the presentations that you attend. You really should, because that's what's going to help you. As a matter of fact, I have a to-do right now on my list. I need to get it done. I want to get it done by Friday, but I've got so many things going on this week. I have a sneaking suspicion I'm not going to meet that deadline. So I'm going to give myself until October 15th. So I'm going to write that down since I just made that commitment. But what I'm going to do by October 15th is I'm going to be updating my letter of instructions. So I've got my to do. I hope as you go through this that you will put down your things to do as well. So let's jump into our topic. We're going to focus now on estate planning basics. What you're doing is protecting yourself and your loved ones. So how much do I know about estate planning? Estate planning is only important for the wealthy. That's not true. That's definitely false. Really, estate planning is for anybody that has assets that they own today and they want them to go somewhere when you're no longer here. Estate planning is only for people who are old. And sadly, that one is not true, because we've known, I mean, certainly if you didn't learn anything from the COVID breakout, a few years ago, and a lot of us did, is that it can happen at any age. Of course, and for a lot of you, you're in the ministry. For those of you who are ministers in particular, in the clergy, you are consoling people when they have losses in their family. And so, this can happen at any age. So it's so important to do this planning in advance. And then joint ownership of property makes estate planning unimportant. That's not true. Most property does need to be spoken for. Also, people think, well, it automatically goes to my spouse. That's also not true. A lot of it depends on the rules in the state you live in. So the key thing is to determine what do you want to happen to what you have, and then put a plan in place for that to happen. I was reading an article recently, and it said 67% of people in the US do not even have a will. They don't even have the most basic document, which is a will, which says, here's what I want to happen to my property. Now, if you are one of those people, well, you're in good company. 67% don't have it. The state you live in actually already has a plan for your property. It's called dying intestate. It goes according to the regulations in your state, which is not necessarily what you wanted. So what I would encourage you to do is to come up with your own plan. It's going to help distribute your property according to your wishes. It will help take care of your survivor's needs. It allows you to specify, here's what happens for medical treatment, as well as handling my personal affairs if I became incapacitated, either physically or mentally, and wasn't able to take care of those things. It also is a way to manage gifting to your loved ones and to charities during your life and when you pass away. And overall, what we're trying to do is help minimize not just estate taxes, but the estate process itself, because if it's going through probate, you actually are paying for the probate process. And if you do a good job at this, you can minimize those fees. So let's start with the basics here. What is an estate? An estate really is everything you own, as well as money or assets that are in your name. So do you have a home? What about your retirement plan? Do you have any life insurance? What about your bank account? If the answer is yes to any of these items, then you have an estate. Not to mention different things that you own, your jewelry, a collection, if you have something like that, all of those things are your estate. So what estate planning can do is it can help distribute your property according to your wishes, help take care of your survivor's needs. And then it allows you to specify wishes and whatnot for these other things. So let me start with those first two items. How do you help distribute your property according to your wishes and take care of your survivor's needs? Well, a lot of that is going to be done one of two ways. It's done through your will, or it's done through a contract or an operation of law. So let's start with what a will does. A will makes your wishes legal. It helps your heirs handle your estate during a difficult time. And then what you can do with a will, you can determine who will receive your property when you die. You can name guardians for your children, should something happen to both you and your spouse or partner. And you can appoint your personal representative or an executor. In the absence of a will, the state you live in will still do this. They will appoint an executor or representative. It will be a lawyer on their list. That person, by the way, will get paid from your money the entire time they're managing the distribution of your property. They will determine what happens to your children. If you have children under 18, the state you live in is going to decide who gets custody of the children, who becomes their guardian, and so on. So ideally, what you want to do is have your own will, which says, here's my executor, here's a potential guardian for my children, here's what I want to happen to my property when I'm no longer here. And that's what the document will do, is the will. Now, that's not the only document you need, but it's certainly an important one. Now, a lot of people think that all property goes through your will. Well, when you look at this chart, wills are only on that right-hand side. Technically, your will handles whatever's not already spoken for, and it has to go through a specialized court called probate. What happens is things are submitted to the probate court, then they have to be approved. Once it's approved by the probate court, then things can be handed down to your heirs. So it is important to just understand that it doesn't necessarily take care of everything. Some documents are considered a contract. So on the opposite side of this chart, we have trusts. Those are a contract. Your retirement plans, your 403B, IRAs, those pension programs, those are contracts. Life insurance is a contract. Those go to the designated beneficiary. Now, some of you might think, well, I've never put out a beneficiary, so of course it's going to go to whoever's in my will, but that's not exactly right. They're going to look to see if the contract names a standard list of beneficiaries. So let me give you an example. If you have a life insurance policy, they have a standard beneficiary clause. I used to work in insurance. I worked in insurance for like 9 years before I got into benefits and working with financial education. And they have a standard beneficiary clause. First, it goes to your spouse. If you don't have a spouse, then it goes to your children. If you don't have children, and so on. So it goes down like about 3 levels or 4 levels until it finally gets to your will. If it finds anybody along the way, it distributes the money at that point. You also have a specific type of contract where you don't need a beneficiary designation and you don't need it to go through probate. And that is if you own property or assets held as joint tenancy with right of survivorship. If you have that, it automatically goes to whoever's left. Whoever the joint tenant is, that person gets whatever it is. So one of the action steps that is very important on this slide, very important, make sure you update your beneficiary designations, including your 403B, your pension, and your life insurance. I can't tell you how often you'll have money that will go to an ex-Mr. or Mrs. whoever because you didn't change your beneficiary information. I did a class last week, and one of the participants told me that she got married and her husband, when he passed away, his individual retirement accounts, his IRAs, they went to his parents. That's who he had listed as his beneficiary, and he'd never moved the money. He never checked or changed the beneficiary designation. And it automatically ended up going to the beneficiary, who was not her in this case. So make sure you review your beneficiary designations, including things like 403Bs, 401Ks, pensions, life insurance, individual retirement accounts. Now, you don't do beneficiary designations for a bank account. They don't list it that way. But what you can do is you can do payable on death. So on my bank accounts for my husband and myself, we have our accounts jointly. If one of us dies, it automatically belongs to that other person. It's basically joint tenancy with right of survivorship. But for whatever's left when that second person dies, it's then payable upon death. And we've named our beneficiaries by doing that. So you just need to do whatever you need to do to make sure all of this happens. Now, the probate process is basically the processing of your will by a special court. They approve your executor or they name a representative if no will exists. And they do have to approve the distribution of assets and payment of debts from your estate. It does cost money depending on where you live. They determine what the probate process is going to cost. So, what are the pros and cons of even going through probate? Well, the court determines the validity of the will. It allows the will to be challenged, and it does all of this supervision. But on the negative side, it can cost anywhere from 2 to 10% of your total estate going to all these different things, and it can take a lot of time. You also lose privacy because it's public information when a will is processed. But I feel like for me personally, I'm not sure who would care. I'm less concerned about the privacy aspect, but I'm definitely concerned about the probate fees. So it's something where you can figure out what do you need to do so you can pass as much as possible, but doesn't have to go through the probate process. And the timing can be a problem as well. Family members that I have that were in California, I had a family member pass away. Everything was submitted to the probate court. And then we sat there and we waited patiently. And I'm telling you patiently, it was 9 months before the probate court said, yes, this is okay. And these assets can be distributed. 9 months. That's a long time to wait. Now, I live in Texas now. We have a very streamlined probate process. I had a neighbor of mine when her husband passed away. Within less than 2 months, everything was settled. So it really depends on the state you live in because the probate process is controlled by state regulations and the cost can be potentially an issue as well. So the key there is to work with an attorney if you can and to have this all drawn up so that you have things go where you want it to go. There are ways to avoid the probate process for some of your assets, and the key would be to set them up so that it can avoid probate. I'll tell you, in Texas, real estate is allowed to avoid probate. You can do what's called a transfer on death deed in the state of Texas, but I don't know that every state has that. As a matter of fact, as long as I lived in Texas, which is now over 30 years, they only put this transfer and death deed in place within the past, I think, 5 or 6 years. So it's not something that's been in place since I've lived here, but they now have a transfer and death deed. It would allow your property to pass outside of going through probate. I have another family member, my aunt, who lives in California, and I had been on her for years to get her estate fixed correctly. She was ignoring me. But what I did is I enlisted my cousin, and she made it happen. And they now have a trust because in California, especially certain parts of California, your property could be a huge asset. Well, if her house, how it was titled, had been left like that, her house would have had to go through probate. And they were going to have to pay based on her current value of her home. They would owe anywhere from $16,000 to $20,000 to the probate court to give her house to her 2 daughters. She's now put it in a trust. That costs some money. It was like $4,000 to do the trust. So that was not an inexpensive proposition. But they invested $4,000 to potentially save $16,000 to $20,000. So in the end, a good decision. So what you want to do is make sure you do title this property correctly. So you can avoid assets by owning something jointly, by creating a trust, by giving things away when you're still alive, potentially by naming beneficiaries or looking to see if your state has some other way to title real property like they do in Texas. We have a transfer on death deed. There's also a right of survivorship document that can be done in California if it meets certain criteria. So the key there is just to make sure you understand what you need to do and then get that in place. If you're thinking of naming guardians for children, you typically are going to name 2 different guardians. You're going to have a day-to-day guardian. That's going to be who has custody of your children and is raising them. And there's also a financial guardian. These can be 2 different people or it can be 1 person. The main thing here, if it's 2 different people, please pick people who get along. Don't pick the oil and water combo. You might think, great, checks and balances, but they need to come together and be focused on what's best for your children. So don't put them in that situation where they've got somebody they just don't get along with. You really want to have people who are going to work together and do it well. As far as your day-to-day guardian, you know what's important to you. You know you want your children to be raised with the the moral and religious values that you have. They have to be equipped to handle that, to add these kids to their day-to-day life, financially capable of supporting and willing to accept responsibility. If you have smaller children, this should not be a surprise. You should have had that conversation with your potential guardians before they're named the guardian. And then financial guardians, financially astute, and most importantly, ethical and trustworthy, because there's not as much, you would think there'd be a lot of financial oversight, but there's not as much financial oversight as you might imagine in some of these circumstances. It is possible for people to do the wrong thing for the wrong reasons. So you want to make sure it's somebody that is ethical and trustworthy. And again, you can choose one person for these, or you can choose two different people. Your executor has a big role as well. That's the person who has to settle your estate. They've got to carry out your wishes, get copies of the death certificate, determine what your assets are, file papers in court, and help prepare your taxes, distribute assets, and so on. So it really is, it's an important job. It's a time-consuming job. So definitely think through who you want to be. Now, I've got to tell you one thing I had learned. I actually learned this as a matter of going to my courses and teaching. Initially, I have two sons. I had initially named one of my sons as the executor, thinking, okay, well, he's got more of a 9 to 5 day-to-day financial based job. He'll understand how to do all this stuff. So I'm going to name him. Then I had somebody in one of my classes, and she said she and her sister, that happened. Her sister was named the guardian by her parents because she was older. And unfortunately, it ended up hurting her relationship with her younger sister because she got a little, kind of full of herself. Well, mom and dad appointed me, so I'm the one who knows this stuff. And it kind of hurt their relationship. And I started to think about that. And my husband and I were going to redo our documents anyway. So we went ahead and we actually listed our sons as co-executors, because the other factor which can impact all of this is we have two sons. They are both married. And so it's not two people that are going to be deciding this now. In a way, it's kind of four people because each of them has a spouse. So we're going to make sure that they work together and that they'll come together and they can assign duties to one person or the other, but each of them still has to account for everything with their brother. So it's just a matter of figuring out what works best for you and for your circumstances. If you've just appointed one of your kids, really the message to the other kids is here's what I'm doing and why, but you still have a right to understand everything is going on. After you've prepared your will, figure out where you're going to keep it. Some people put it in their safe deposit box, not recognizing that the only people who can get in your safe deposit box are people on that box, and it may not be who needs to get in there. So you need to figure out where you want to keep it so that it's in a safe place. Make sure you have copies of it, and then set a date for review. You should review it every 3 to 5 years, or if there's any big change to your marriage, if there's marriage or divorce, if birth or death of any of your potential heirs or executors happens, if you relocate to a different state, you want to have it reviewed, or if there's a change in the laws. As a matter of fact, my husband and I, we had done our wills probably 10 years ago. We had them done. And then we redid them, I think it was 2 years ago, and we decided to redo them for two reasons. There was a change in family relationships. So there was an heir that hadn't been there before that wasn't named. And the other issue is the law changed in Texas as it relates to a living will. So we wanted to make sure that our living wills were valid in Texas. And so since we were going to redo it anyway, it was like, you know what, let's just go ahead and update everything so that it's in alignment with what we want at this point in our lives. And it just depends on your state whether you need a trust or not. We're in Texas. Our probate process is pretty streamlined. So a trust is not something we need at this time. And a part of that is because our kids are older. My oldest child this year, I almost have a hard time thinking this, but my oldest child's going to be 40. I'm like, which is kind of crazy because I'm just 43. I don't know how that happened. At any rate, my oldest child's going to be 40 and his brother is 38. So I don't have to worry about, are they old enough where if there's anything left and they get the money, will they do okay? But if they were only going to be 18 or 19, I would want to put strings and conditions on the money. And that means I'd need to look at a trust. So again, you look at your personal circumstance, figure out what you need, and ideally work with an estate planning attorney to put it all into place so that you have the financial documents that will and take care of it. A trust is more expensive, but the idea is that you can put terms and conditions on the money being used, and you can potentially avoid probate and avoid additional expenses when it comes time to settle your estate. How a trust works is you basically, somebody owns the property right now. They're going to give it to the trust, which is a legal document. It's going to be controlled by the trustee and used for the beneficiaries. So what's unique about this, like in the case of my aunt, she owned the property. She gave it to the trustee or to the trust, which is a legal document, which meant her house is now owned by her family trust. It's had to retitle the house. It's owned by that, and she's the trustee. And then she's named successor trustees. So should something happen to her, then her daughter takes over the trust, and it'll be used initially for her because she's the first beneficiary on the list. She's not married. My uncle passed away many years ago. And so it then basically states, here's what would happen until everything is completely given away. Now, if you're trying to give something away forever so that it is not a part of your estate for tax purposes, it does have to be what's called an irrevocable trust. But that would be a circumstance where I think only a small percentage of people might need that if you really have pretty high wealth. Like if you've got more than $5 million in assets, you should be talking to attorneys. You should be looking at irrevocable trusts. If you have less than 5 million, you're probably in good company with a lot of other people like me and you don't necessarily have to worry about it being irrevocable. But what estate planning is going to do is look at, here's what you have, where do you want it to go, and then assist you in determining how to make that happen and putting the right documents in place. So we've really focused right now on documents which will declare how you want your assets to be transferred once you have passed away. But there are other documents you should have which specify medical treatment and handling of personal affairs while you're still alive. So it's not just a will. The other thing you should look at having potentially is a durable power of attorney. So a durable power of attorney, this grants somebody the ability to act on your behalf for non-health related matters if you become incapacitated. So it's for financial matters if you become either mentally or physically incapacitated. I've seen this one happen so often. There used to be a column I would read that provided legal advice when I lived in the Houston area. It was in the Houston Chronicle on Mondays. They had the legal column. And at least once a year, this exact same letter would appear in the legal column. And it would say, my spouse now is suffering from dementia or Alzheimer's, and I really need to sell the house. What do I do? The answer was always, do you have a durable power of attorney? If so, you're fine. You can sell the house and do anything else you need to do. But if you don't have a durable power of attorney and your spouse is unable to sign any legal or financial documents, you would actually have to go to court to be appointed your spouse's guardian, which is a expensive legal process. And financially, you're going to have to pay money for that and have all these other rules you have to follow as their guardian. So what you do while you're still able to is to do this durable power of attorney. It allows somebody to act on your behalf regarding financial matters only related to if you became incapacitated, either physically or mentally. In addition, you can do a healthcare power of attorney, which only speaks to healthcare. And typically it also includes what's called a HIPAA release, which would allow people who are your healthcare power of attorney to also be released any of your health information, which requires special approval based on federal regulations. And so the other two documents are a living will and a healthcare power of attorney. So I want you to have a will, a durable power of attorney, a healthcare power of attorney, and including a HIPAA release, and a living will. So why I redid our documents or wanted to redo those, my husband and I both redid these documents, it's because the state of Texas changed their standard format for a living will. This is the document where you specify which services do you want or not want in the event you need life support and you are unable to provide directions. So I'm in a coma. I can't say, here's what I want or don't want. My living will says, I don't want to be on a respirator. I don't want to be on a feeding tube. I don't. Or it could say, I want this, but I don't want this. I want this, but I don't want this. But this is your opportunity to tell us what you want if something were to happen to you. So your will, and you may also need a trust depending on where you live. You want to do your will, your living will, your healthcare power of attorney, and your durable power of attorney. Now, the other document, the one I wrote down, I need to update by October 15th, is my letter of instructions. And your letter of instructions, this is not a legal document. It's not something where it's binding. It is just your suggestion of here's how I want this stuff handled. And so it's a non-legal document, but it expresses your thoughts and direction regarding what is in the will or about other things. It's your burial wishes. It's explaining why you chose one person to be executor and not everybody. It's advising your executor or your beneficiaries. It's letting them know where things are. One of the latest things I'm doing in my letter of instructions is I don't have a lot of jewelry that's nicer, but I do have a few things, and some of them, they were my mom's or my grandmother's, and they're people who are no longer here. I have now taken pictures, and I'm going to do a little document which says, here's what this is, and here's why it was important to me. This was my grandmother's. This was my mom's. I bought this when I went on this vacation or whatnot. You know, they can decide to throw it all away or give it all away or sell it. It really doesn't matter, but I would like them to know why those different things have significance and why I kept them. So I'm going to add that to my letter of instructions. My letter of instructions, just like yours should, also tells them here's where to find everything. Here's where these different documents are, and here's how to contact your attorney if you have one, your accountant if you have one, your life insurance agent, your financial person. So it's really figuring out where all this stuff is and how to take care of all these different resources on your behalf. And don't forget about digital resources these days. Without planning, they may not be able to access your Facebook account, your Instagram page, your whatever other social media you have in place now or that comes along in the future, your email, your online payment systems. You know, today, a lot of your resources, they're not even going to know if you have them because we don't get a lot of paperwork in some cases. I don't get a lot of papers. You have no idea which bills I owe unless you're able to get into my computer and get into the spreadsheet where I track all of that. So my letter of instructions informs my family on how to get a hold of all that information. Most states have enacted rules or they're working on rules to allow you to access the digital assets of a person who has died. And this is just a reminder of the different things that you're going to need to take care of or have your family have access to understand what will happen to those things when you pass away. So figure out what you're going to do that letter of instructions. Don't forget about digital assets. And so sort of a summary of the documents I've talked about during your lifetime, it would be that financial power of attorney. So that's my durable power of attorney for finances. It's healthcare power of attorney and a HIPAA release. It's a living will if you need to do trust, depending on where you live. Make sure if you've done a trust that you've retitled your assets. And of course, that letter of instructions can come in handy. But these are all things that can help you while you're still alive. And then when you die, it's your will, those trusts, beneficiary designations, the letter of instructions, and the document locator. And then you ideally want to meet with an estate lawyer to update or draft important documents. I will tell you, when we did our wills, I think it costs, so I didn't do a trust, but I think it cost $500 or something around that for my husband and myself, for each of us to do all of these documents for us. So, but again, a trust is going to be much more expensive. My aunt paid about $4,000 and she lives in California. So that'll sort of give you an idea of what to do. Now, if you've got a very easy situation, there's never been a remarriage, there's no kids from a first relationship or whatnot, you might want to go ahead and you can do this on your own. Most states have rules for writing out your will. Actually, there's 26 states that allow you to do your will in handwriting. It's called a holographic will. Or there's some of these online services that will produce a valid will. You can fill in the information. But my challenge with those documents is recognizing that if you do it wrong, we won't know until you've died and it's too late to fix it. So if you have a complicated situation, you really should work with an attorney to make sure you get those documents drafted and that they are in line with what your wish is. Also think about what about gifting during your lifetime or charities during your lifetime or when you die. You can actually give up to $18,000 per year per person without paying gift taxes. Gift taxes are the responsibility of whoever gave the gift. The IRS is pretty smart. They said, okay, if you can afford to give the gift, then you can probably afford to pay the taxes too. But you can give away up to $18,000 per person. And between you and your spouse, you can give away 36,000. And then other than that, they have a unified credit, which is $13,610,000. Now they're saying basically you can give away that with no federal estate taxes. But anything over that, you may have to pay estate taxes on. So gift taxes don't apply up to that other limit. It also doesn't apply if you're directly paying somebody's medical expenses or educational expenses, or for gifts to your spouse, as long as they're a U.S. citizen, or to a charity, a certified 501c3 charity, which of course, churches and a lot of other organizations are eligible charities. Now, gifts to loved ones during your lifetime, they can reduce your taxes. And they can reduce the size of your estate after you die. And of course, gifts to charity can reduce your income tax during your lifetime, as well as reduce the size of your estate after you pass away. The main thing before you give away a gift, even to your children, just be sure that you and your spouse are not going to need those assets for your lives. So keep that in mind. And then overall, what estate planning can do is it can help minimize estate taxes. So they look at all the things that you own. You can see at the top of the chart. We add all of those together. We subtract out your expenses and liabilities, and that's your adjusted gross estate. Then anything that would go to your spouse or charity, the rest of that is your taxable estate. And then here's an example. So we've got Josh and Amy are my couple right here. And they've got a lot of money tucked away in their 403b accounts, as you can see. Plus, they've got a lot of money in their IRAs. Then they've got some mutual funds and the value of their house. And they also have some life insurance. So their total assets, which we're showing you here, come up to be $2 million in total. And so they're able to basically give that away without having to pay any taxes. Now, will you owe taxes? And here's why it is an issue. Right now, those numbers are big, big, big. I mean, this year's number is $13.61 million. That first dollar over 16.61 is taxed at 40%. But the tax law that changed it to these high numbers is going to expire at the end of 2025. And then we're going to go back to the regulations that were in place in 2017. And the rate at that point, it says 5 million adjusted for inflation, but based on inflation during that time frame, it's probably going to be closer to 6 million. So for a lot of us, 6 million is still fine. But if you are over and above that, I would say you should definitely consult an attorney who specializes in estate planning to assist you in that process. So how can you reduce estate taxes? You can do direct payments for tuition or medical expenses. You can do charitable deductions. There's a marital deduction. And then we've got this overall unified credit. And really between a married couple, you could give away double that amount. What needs to happen is when the first person passes away, you actually have to file an estate tax return for that first person, even though they don't owe anything. Let's say it's all going to the spouse, and you have to retain your ability to give away that additional money. So it's just some things to keep in mind as you go through this process and do your estate planning. One of the nicest things you can do for your family is to do a good job at this. We had a family member and she had a really bad heart condition, and she just knew that she was not going to live as long as we all wished she would have. She was in her late 50s when she died of her heart condition. But she had put together, here's what I want for my funeral, and here are the things that are going to happen as far as my property and so on. So as hard as it was to lose her, it was really nice to be able to do the funeral we knew she wanted. And she even sent a message with a friend of hers. She, after the funeral was over and we're all sitting around sharing wonderful stories about what a great person she was, because she really, truly was a lovely person. Her friend said, yeah, she put everything together because she said when she died, she figured she said, and I will quote her, She said when she died, she figured you fools won't know what to do. And in fact, she was right. We really didn't know what to do. But having been a teacher, she put together a lesson plan that said, here's what I want, here's what I want to wear, here are the hymns to play, and so on. And it was a beautiful service and a beautiful tribute to somebody who was very well loved. And we were able to do that and feel good about that because we knew exactly what she wanted because she'd done a great job. So the hard part, because we do live in the U.S. and we do not like to talk about death here. It is not something we want to have a conversation about, but you want to have the conversation of what happens if I die? What happens if you die? What happens if we both die? And really talk about, do we want additional insurance? Are there any special things we want to do? And then make sure you're working with somebody who specializes in this kind of stuff. Seek a lawyer that specializes in estate planning. Um, you also make sure that you understand the fees that they'll charge. Are they going to communicate clearly with you? So you can talk to people you know, maybe ask people in your circle of people that you hang out with. Is there an attorney that they recognize or that's done a good job for them or whatnot? I found out recently because my girlfriend, her husband passed away. We live in a community that's predominantly retirement. You have to be over a certain age in order to even buy property here. Well, there's an attorney who has retired from day-to-day practice, but they specialize in estate planning and they will do estate planning documents by referral. So if you get a referral to this person, they'll put together your documents for you and they're very well respected. They're known for doing a great job. And they also don't charge that whole like $500 a person like some of those other standard lawyers do. So ask around and get started on that process. When should you review your estate? If you get married or divorced, if you have a birth or death of a spouse, beneficiary, executor, if you relocate to a different state, if the laws change, and then every 3 to 5 years, you might want to look at this. That was another reason I wanted to review my estate planning stuff. My husband and I had done things, and of course, I work in this stuff all the time. I'm always talking about financial stuff, and my husband was talking to somebody, and he said, "Well, when I pass away, here's what's going to happen." And I'm over there like this, like, not exactly. That's not what we wrote down. That's not what's in the will. That's not what's in these documents. And that's when we realized, oh, maybe we need to revise this. Maybe we need to redo what we're going to do. And we ended up deciding to do that. So you just look at your personal circumstances and you can decide if you want to make any changes. And as far as tools and resources, we are not a legal firm. We are not attorneys here at EY. Actually, mostly we're accountants, but we can help you understand the documents you'll need. So you can call our planner line. They can help you understand the documents you might need. We're open long hours, 9 a.m. to 8 p.m., Monday through Friday. That's Eastern time. There's a data on our website, which can help you understand what you might want to do. And we have regular webinars where we share information. And so our planner line can help you discuss your planning goals, understand your current estate plan, identify potential gaps, and then help you understand what you'll need when you go to prepare and meet with an estate planning lawyer. We can also stay in touch and help you monitor and update your plan. So I would say take a little time, go back and look at the different information we've shared in here, and hopefully you will pick out a few things you want to do. I know I already have a to-do list. It's right here on my list. I want to update my letter of instructions. I put it on this handy little Post-it note that I bought at In-N-Out Burger. Yeah, I don't think you can see it, but it's shaped like a little hamburger. So I put that on my list. I'm going to put it on my regular to-do list. I'm going to update my letter of instructions. I hope that you will hear the words we talked about here and get inspired to do some of these financial things to put your estate in good order. It's a great idea to do that. Nobody wants to talk about it, but it's still important. If you would like to give us feedback on today's session, you can send a note. You send it to its Workshop Wespath, basically, WKSP space Wespath, and you'll have the ability to link to our workshop evaluation. You'll let them know this is workshop number 43790. And I looked, I don't see that I have any questions. But if you do have questions in the future, do know you can call our planner line. You can look up information on our website. I just encourage you to use those resources. They're absolutely free to you through the Wespath organization. I encourage you to use those. get started in your planning process. And then other than that, I just want to wish you a great rest of your day and have a wonderful afternoon. Hopefully, I'm going to be able to shut off our workshop because I know my coordinator had to leave to go to another online meeting. And you will be able to, you'll get a link, you'll be able to rewatch these. And for those of you, if you are watching the link, thank you for tuning in. If you do have any questions, contact our planner line. So thank you and have a great rest of your day.